Hi, everyone. I hope I'm audible now. Thank you so much for joining us today. On behalf of the Internet Law and Policy Foundry, I'm very excited to welcome Jhalak and Kirti, two of India's foremost experts on the subject of India's new data protection law that, for those of you who don't know, became a law earlier in August. So we are very excited to bring together a panel of experts where you can explore the commercial and the civil society perspectives on the law at the same time and sitting across each other on the same table. Jhalak is the executive director of the Center for Communication Governance, which is a leading think tank in India and has been involved with the many different versions of the law that have passed through the parliament, through many expert committees before it finally became a law. Kirti is a partner at one of India's leading law firms, Shardul Amarchand Mangaldas. And Kirti's team has also been involved with many versions of the law, presenting the industry perspective and engaging with the different mechanisms that have been gone into making this law. My name is Raktima. I am a fellow at the Internet Law and Policy Foundry. I am also an Indian data protection lawyer. I used to work with Kirti before coming to Georgetown for my second law degree. And right now I am very excited to create this channel, sort of bridging the tech policy worlds of India and the US and bringing them together. So over to you and over to the panelists. I'll just start off with a brief overview of the law, which is for those of you who might be unfamiliar with it, and then our speakers can supplement with whatever other pointers there are that are important for the law. And then the way this session is structured is that it will be somewhat of a free-flowing discussion, a Q&A, and as audience, you can ask questions either on Zoom, or if you're joining on LinkedIn Live, you can also leave comments on the LinkedIn session, and we will pick up as many of those as we can towards the end of the session. Okay, with that, we'll start off. So as an overview of the law, it follows many of the global laws that most of you must be familiar with, similar to GDPR, for example, and other laws where you define personal data as data that can identify a person. And then there are data fiduciaries who are essentially companies that are handling your data, similar to data controllers under GDPR. And the person whose data is being handled is called the data principal instead of data subject. And there has been a lot of back and forth on what these names mean and whether they signify anything specific, which I will let our panelists take. In terms of how the law is structured, in order to process any personal data, you have to go through one of the grounds of processing. Consent is the main ground of processing, and then there are a few other secondary grounds, mostly based on emergencies, employment purposes, etc. There aren't contractual necessity or legitimate purposes, or those kinds of purposes that are common in laws like GDPR don't seem to be present in this. We also don't right now have any restrictions on cross-border flow of data. So, if you're watching as a foreign company or someone whose business involves a lot of data flow across borders, so far, there's nothing in the law that stops you from doing what you are currently doing. However, the law does leave an opportunity to notify rules or regulations under it that could in future allow for any restrictions to come in, whether it's a restriction based on don't send data to this particular country, or don't send a certain kind of data outside India. It could be anything. We don't, it's not been clarified in the law. So those are the main points. This is also a law that actually has duties for data principals or data subjects. And if you don't follow those duties, then there are actual penalties. And what the law does by way of setting up an enforcement structure is that a lot of the law has been left to be notified later on by rules and regulations, a lot of the details. So for example, with child data, it says that you need verifiable parental consent to handle it, but what that means is something that has been left to be notified by rules. Similarly, as I mentioned, with cross-border flow of data, any restrictions in future has been left to be notified by rules. So even though this is an exciting step forward for India, in terms of actual compliance, there is still a lot left to be notified. And we don't yet know when the law will come into force or be notified as from today it's operational. It could happen in parts. There could be certain sections that come into force first, and then other sections that come into force later, and so on and so forth. And as I was saying, the enforcement structure is that once the central government notifies these rules, there is a board or an authority that has been set up, presumably as a regulator, but they don't have powers to issue regulation. The power that they essentially have is quasi-judicial power, where if as a data subject you are aggrieved by something, you first approach the company that you're aggrieved with. And then if that doesn't work, then you approach the board, and then there's an appellate mechanism that has been set up from there. So that is kind of the enforcement structure. And yeah, that's the general overview of the law. I am going to now stop talking and hand over to Jhalak and Kirti. If you could first, any other interesting aspect of the law that sort of jumped out to you, if you could tell us that. And also if you could give us just a brief overview of your own professional journey around the law so that our audience has some context on what it has been like for practitioners on the ground. So Jhalak, do you want to go first?
Thanks, Raktima, and thanks for organizing this discussion today. Yeah, I think in terms of professional journey around the law, it's been a long time that this law, the journey around privacy and data protection really started more than a decade back in India with, the coming in of Aadhaar and questions around privacy and data protection rising from there. Of course, Puttaswamy, and now we are celebrating more than 5 years of Puttaswamy. The landmark Supreme Court judgment that really reiterated and brought to the fore the right to privacy within the Indian context, and in that sort of space is where the government, in response to comments made by judges during the hearing of that case, went back and said they will set up a government committee led by a former judge to really map out what data protection legislation can look like within the Indian context. And it's been a long time that we've gone through many iterations of the law. We had the Justice Sri Krishna Committee report and the proposed law, which CCG did provide public input towards. We had a government modified version of that bill, which again, was introduced in Parliament, and CCG did provide input for. And we did interact with this parliamentary committee that was looking at this. And of course, there was the iteration of the law that was brought in towards the end of last year in Parliament, which we did publicly sort of write about and comment on. And then, we had this final version of the law that came in with several new provisions, but very little opportunity and time to respond to them. And it was passed within a few days of being introduced in Parliament. So I think
all of these consultations, there's the final version is not something that you got much chance to engage.
Yeah. So I think, as I was saying earlier to you, we do have a law, which in and of itself is great. But there are sort of many aspects of the law that would have been ideal to have provisions that align with best practices globally. But I think it's also important for us to really focus on the fact that we now have a law and what does implementation and design of institutions envisaged under this law look like? How do we ensure data subjects are able to access the rights envisioned under this law? But I'd love to hear from Kirti.
Uh, Thanks, Jhalak. And thank you, Raktima, for having me. This is, well, like most of us know, as technology and privacy lawyers here in India, like a monumental task that we've sort of been involved with. Each and every one of us has had their share of involvement with this lawmaking process, and it's been, amongst other things, something that has tried our patience, I would like to say, I think. But that said, I think completely agree with Jhalak that we at least have a law. A starting point is what I would like to call it, because we are looking at a principles-based legislation. And I think there is, at least with the government, what we appreciate is the clarity that they have with respect to how they intend to govern the tech sector. In India, given the implications that regulation is going to have, not only in our country, but across jurisdictions, for a variety of reasons. And I don't want to go into each and every one of them. But that said, they're very clear that they're looking at principle-based legislations for anything that has to do with the Indian technology sector. This is something that we will also see with the Digital India Act, which they are saying is going to be proposed replacement to the information technology laws that we have currently as applicable law, which is also, again, going to be a massive mammoth task that they have taken up on themselves. But whether, like, what happens of it, how long it takes, and especially when we also at the same time have 3 new criminal codes replacing India's more than hundreds and years old criminal laws, which we got from our colonial rulers, whether they're going to be fast or slow about the Digital India Act also, for example, is something that we have to wait and watch out. We are looking at another 7 years, I'm not sure. But it's been an interesting journey in the sense that over the years, we've seen greater clarity from the government about where they stand on certain issues. And I think there has been a slight shift in the government's stance with respect to how they approach the technology sector. And I think they've gone from hard coding regulation to principle-based legislative frameworks where they feel that it's dynamic enough to take into account changes that would be thrown up by the technology sector, because the law in this sector is basically going to go where the technology takes it. So to that extent, it's been an interesting journey, absolutely. It's been of course, a really long one. And there have been many lessons at an individual level. And also as a policy lawyer, I think some of the interesting things that we've seen is how policy tools have been utilized by the government in this current draft. And I would love to call a couple of them out. What we really appreciate going forward is the fact that the law now provides within it, hard-coded, the requirement of public consultation for the rulemaking process. It basically will mean that all rules which will be drafted by the government have to be published for public consultations. They will take into account any and all comments that they receive on that law, which we feel is a big win, considering the fact that this was something that pretty much any and every stakeholder has told them that if you are thinking of a principles-based legislation, you must allow for public participation in the rulemaking process. So that definitely a unique and nice feature to have in an Indian law. That said, a couple of things that did jump out to me in this current draft, because like Jhalak said, there have been multiple drafts and there were good things and bad things in pretty much all of them. But that said, what really jumped out to me as a practicing lawyer who advises on the commercial aspects of compliance with data privacy laws in India is the fact that they have taken into account that compliance is going to be long drawn. So they have to give the benefit of the doubt to data fiduciaries who are complying with this law. So not having penal provisions around non-compliances is obviously welcome, even though the penalties can be a big number. What they've also put in place is voluntary undertakings, which data fiduciaries can provide. And that's something that is, I think, what businesses should really focus on. That if it seems to suggest that the data protection board, which is supposed to be set up, will possibly take into account any voluntary undertakings a data fiduciary will provide to show how they would do compliance in case they've been accused of not having complied with a requirement under this law. So a couple of things like these, I feel, are right steps. Of course, there are issues in this law around how exemptions are working and whether the data principal rights are sufficient. Is the notice and consent requirements that we have in place are actionable? What does it mean from a compliance perspective, given that there is not a lot of clarity and we have close to 46 subjects under which there is rulemaking power. So we are looking at like massive levels of subordinate delegation, subordinate legislation. So yeah, it's a mixed bag. And what we really appreciate is that going forward, it's going to be a consultative process. So that's sort of the key thing for us here.
Yes, that's a really important point, especially because there has been kind of a history of rules being notified rather suddenly and people being caught unawares to some extent. So that's great. Kirti, another question that I would ask you is that for companies that are watching this from abroad, the law does have extraterritorial obligations, but can you speak a little to when they need to be concerned about the application of the law? I mean, is it only when if someone has a website that's accessible everywhere, including India, do they need to worry about it? If they have, say, not much of an operation in India, but they have some employees sitting there doing some back-end work, versus like, let's say it's a B2B company. So can you speak to some extent to when a company would need to be concerned about applicability of the law?
Sure. I think at a first level, any organization outside India which has any sort of operations which involves processing of personal data, the first round of determination they need to make is what is the role they play with respect to that data, which is true for any privacy legislation. You basically need to determine whether you are controlling the means and the purposes for which the data is being processed, or are you processing the data on the instructions of another entity. If you are a data processor, then of course this law does not necessarily identify a whole bunch of requirements. I'm sorry, please excuse me. I think I've lost video. Please give me a second.
Sure.
My apologies. Yeah, so what I wanted to say was that first level of determination is that what is the role that they play, if at all they are processing personal data of data principals who are in India, for example. The next set of questions that they have to ask themselves is what is the purpose for which they are processing that data, and what is the source of that data. As you're aware, this law now says that any processing of personal data which is publicly available, voluntarily made publicly available by the data principal, is outside the scope of the law. So it seems like certain kinds of, and I wouldn't want to comment on the laws in other jurisdictions where even web scraping of personal data publicly available can still attract compliances under the local privacy laws in that jurisdiction. But what the Indian law seems to suggest is scraping publicly available personal data would fall outside the scope of this law. So after they've done a determination of the category of regulated entity they might want to think about the sources from which they're getting their data, and whether that's publicly available data or not. Now, once you've done that determination, to your specific question, Raktima, as to whether just having a mere website is enough, or if you're processing the data of 5 people versus 1 people, this law is pretty clear on those lines. There is no graded applicability. It's very clear that if you are a data fiduciary who is basically processing data of data principals in India, with the intention to provide services or products, even if it looks like it's one time and not necessarily systemic, this law would apply, which we feel is essentially inadvertently going to bring in a lot. It's casting a much wider net, because previous iterations of this law did talk about systemically providing services and products in India, versus now which just says processing for providing any goods or services in India. So I think they've widened the scope of applicability, and there is every possibility that there are entities out there who would like for one time ship a product to India, like, one sale, because somebody has discovered their website and it's accessible from India. So it appears like the law would apply if you just go by the black and white. But whether enforcement would go down to that level is going to be a question. And whether we even have how our institutional mechanisms around enforcement get developed under this law is also going to be a big question. But yeah, these are some of the issues that foreign entities need to think about. And the fact that this law gets applicable to them, and if especially they do not have a legal presence in India, or even, let's say, any sort of employees working out of India, etc., how would they go about complying with this law is going to be a big question. Yeah, these are some of the issues to possibly ponder on while we are still looking at a law that's not notified, is currently not applicable. So some preparatory work on impact is definitely recommended.
Cool. So I will pick my next question based on one of the things that you just mentioned, which is that you said that, if data is publicly available, then that's completely outside the scope of the law. And it seems that the law also says that if any data by the data subject has been made available, then, the law doesn't apply. Now, the thing is, like a computerized web scraper is not really going to. So if I, for example, on a public platform, put up your address, Kirti, which I assume is not publicly available information that you have put up anywhere, would be pretty hard for like a machine to figure out whether you have put it up or I have put it up. I don't know how that is going to play out, and whether there will be some kind of barrier imposed through that measure. So
no, absolutely.
Yeah.
I completely agree. Any automated means of scraping, obviously the bots are not going to make a determination of what's publicly available or not. And that is where we feel that even though there is an exemption from applicability of the law, it's not going to be very straightforward. We can't just, this is the reason why I said that it looks like this is going to be a web scraping of personal data, publicly available personal data should be fine. But I do not think that it is that simple. Because you're absolutely right. You don't know in what circumstances that data has been made public and whether it meets the requirements of this law, which basically says it has to be made public by that individual, or it has been made public on their behalf because of a legal requirement, right? So how would a bot make those determinations? So completely agree. It's not a straightforward answer with respect to applicability.
And Jhalak, as an AI expert, like, what are your views on how this law will impact artificial intelligence, whether it comes to training or generally, if you have any thoughts on the law not specifically mentioning automated decision making or giving any rights against it? Do you have any thoughts on that?
Yeah, I mean, I think it seems to me that this is one of those provisions that came in the last iteration of the law, and I think we're all still trying to understand what's motivating it and where it's coming from and what the implications are going to be. The Minister of State in a public sort of briefing on this law seem to articulate it actually differently from what we are seeing in the law. So it really remains to be seen how it plays out. But if you just go by the provision of the law, it seems to be really something that's going to give a boost to the AI ecosystem and enable practices for, AI systems like ChatGPT and other generative AI systems that really live off of scraping publicly available data en masse from the internet. However, I think if you go back to fundamental principles of data protection and really the foundation of data protection, the idea is that just because information is technically accessible and collectible doesn't imply that we should enable this, whether through law or other sort of practices, and there's a need for obligations on third parties. There's a need for looking at mechanisms like consent. I mean, one of the fundamental principles of data protection is purpose limitation and data minimization. So how do we talk about the interaction between how this provision is being envisaged versus some of the core principles within data protection? How do we talk about, the right to erasure on one hand, which is recognized by this law, versus the ability of a company to scrape publicly available data? And I think if you go back to sort of the foundation of the right to privacy, and you look at jurisprudence, you look at the landmark case of Puttaswamy, and it's a settled position of privacy law that, just privacy law doesn't only protect you in the private realm of an individual, but it also, as an individual, you also enjoy a measure of privacy within the public space as well, right? And there are various layers and spheres of, there's a range of what is private to public, and then the question arises is, if I'm posting something on my Instagram and it is accessible to a certain number of people, whether a company should be able to sort of scrape that. What is the definition of something being completely public or not? What is my expectation of what I'm putting out and how that's going to be used? So I think, this is going to be definitely a contentious provision, which I think is going to need a lot of clarification by the government through rules and regulations. It perhaps may even see some litigation, as lawyers gear up and analyze provisions of this law, and, if they choose to, really challenge some of the aspects of this law before constitutional courts.
And sorry, just to add to this discussion, because web scraping is always been a big contentious issue, especially in India with no clarity. And I wanted to call out that this provision will also, lawyers will have to advise, keeping in mind that we will still have the IT Act to deal with while we are looking at implementation of this law. The IT Act is very clear that if you do unauthorized access of a computer resource that belongs to a different person without their permission, that is a punishable offense, which a lot of times we do rely on while we are giving advice with respect to web scraping, for example, in India. And our advice always is that if you do have an identified list of websites, please do read their terms and conditions to see whether they do allow or disallow scraping. And given global trends, most platforms which host personal data, they do in their terms and conditions make it very clear that they do not allow for web scraping, for example. So these are nuances that have to be kept in mind. Like I said, it's not just because it's called out as an exemption doesn't necessarily mean that suddenly the entire gamut of web scraping activities is allowed for personal data that's available publicly in India.
That's a really important nuance, yes, and probably brings us some degree of relief as data principles as well. And with that, I also want to pivot into data principle or data subject rights. To some extent, some of the rights like right to access, erasure, correction, etc., are fairly standard across the globe, but there, for example, there doesn't seem to be right to portability. And then there are also all these duties on data principles, which is unusual because you shouldn't really have to perform any duties at all for you to have your rights. In a data protection law, I would like to hear from both of you briefly on how you see that playing out and what your initial views on that are.
Yeah, I mean, I think this law, of course, doesn't have things like a right to be forgotten expressly articulated within the law, which we have seen in various other sort of data protection frameworks that have emerged globally. I think one of the things, if you're talking about a data subject or a data principle, and something that really stands out in this law in comparison to other global frameworks, but also if you compare it to earlier versions of this law, is the fact that they've removed any sort of idea of a data harm. So like you're not talking about harm to a data subject, right? A privacy harm or a data harm. What this law really focuses on is really the idea of data breaches, and violation of data subject rights to say information correction or erasure. So what ends up happening is you actually have a very narrow definition, or narrow idea or space, ambit around which someone can file a claim before the Data Protection Board, which is the quasi-judicial body envisaged under this law. And you don't have a broader sort of sense of there are impacts and harms that arise for data subjects which go beyond just a data breach, right? There's mental harm, there may be physical harm, there may be psychological harm, and this law doesn't sort of take that into account. So in a sense, it's almost like a compliance based checklist law, which is why a lot of companies are in many ways very happy with this law. Of course, while no one is completely happy with anything, but you'd see that companies are on balance much happier with this law than other consumer groups or civil society groups. So I think and coupled with the fact that there are these strong obligations and duties on data subjects, and also sort of these enumerated criteria based on which they can access the Data Protection Board for sort of a data breach or judicial proceeding. And the fact that costs can be imposed on a data subject if they found to have brought a frivolous claim. It almost seems like the institutional architecture is being designed in a way to disincentivize. Not only have you narrowed the ambit of what a data subject can bring forth as a claim before Data Protection Board, but you're imposing all these restrictions and duties and penalties, which almost disincentivizes the data subjects to come forward. And you don't necessarily see something as, I mean, while of course penalties have been placed on companies, but there's almost a threshold of, okay, something significant has to be done by a company before a penalty will be imposed. So it just on balance just doesn't seem like it's making a lot of sense in the way these two actors are being treated under the law.
That's quite interesting, and I would also venture to say, and with the caveat that when I was working in this field, it was obviously more like I was in a law firm, so I was more familiar with the commercial side of things. But would you agree that in the many different iterations of the law and the things that have changed over time, fewer of the civil society or organizations' comments or concerns have sort of been allowed to inform the final version of the law as compared to what the commercial concerns are. For example, localization was like a big thing that naturally, for very good reason, was commercially pushed back against, and we don't have that provision anymore. But a lot of other provisions, such as, for instance, wide government exemptions, which I think was the biggest talking point for civil society, it seems to still be the case, if I'm not mistaken. Any thoughts on that?
Yeah, I think, yeah, definitely, for instance, the government, as it was doing consultations around previous drafts of the law, did say that they aren't going to publicly release and put out all the comments being sent by various stakeholders, right? And I think that's sort of one way for various stakeholders in the ecosystem to really understand what various groups of stakeholders are asking for, and then what we're finally seeing reflected in the next iteration of the proposed law. And without access to comments being submitted by a cross section of stakeholders, it's really hard to assess who is pushing for what and who believes what is appropriate for this law. So Yeah, and I think, we did hear of a lot of consultations, closed doors happening with industry and industry representative organizations. And you didn't necessarily hear of a lot of similar stuff happening with academia, civil society, consumer groups. So yes, I think there was definitely that imbalance in the process.
Got it. So since we only have about 10 minutes left, I will ask a couple of questions, and then, we'll take any questions that maybe they're from the audience. Most people are attending on LinkedIn, it seems, based on what I can see. So one question that I had personally, I was very intrigued that when it comes to children and people with disabilities, it says that their lawful guardian can be the data principal, not that their lawful guardian appointed under a certain law, etc., can exercise certain rights under some circumstances. That's not what it says. It just says they can be the data principal. So for instance, I mean, it also doesn't, as far as disabilities are concerned, it also doesn't make any reference to disabilities as defined by the Rights of People with Disabilities Act or anything else, which means really, which is a fairly unusual approach to take. So Kirti, I would love to hear from you on how like a company would operationalize something like this, and Jhalak, from like a rights-based perspective, what are your views on taking this approach instead of just like giving limited right to exercise some powers on behalf of the data principal?
That's a great question. I mean, we do have these two, what we would like to call categories of data principals who would have what is expected under the law, a different consent journey when it comes to their personal data. What's interesting is that in one of the previous drafts of this law, with respect to children, what we had seen was the right to basically, once they attain the age of majority, to review a lot of the consents which were provided on their behalf by their parents or their lawful guardians, and then to make a determination as to whether they would want to continue to give that consent. Now, even that has been sort of taken out from this iteration. Not sure where the government is coming from when it comes to thinking about agency of children, and especially young adults, because even from like, the commercial side of things, the fact remains that if you are thinking of a futuristic law, you have to take into account the fact that there are internet users who are below the age of 18, these young adults who will absolutely continue to use the internet no matter what. And to not give them sufficient agency under this law is something that has been an interesting choice that the Indian government has made, and for them not having the ability to go back and review some of these decisions that will be made on their behalf is also extremely interesting to me. But keeping my personal thoughts aside on these two categories of data
Your personal
principles, when
thoughts
it
are
comes
very
to
welcome.
Coming to operationalizing compliance, like I said, we are basically looking at a different consent journey for them, right? Now, whether parents and legal guardians have to act as consent managers, or are they supposed to go above and beyond and think about what they're consenting for and exercise rights appropriately, etc. That's going to be something that will play out as we look at enforcement. But if I can just spend just a minute on how that consent journey is going to work, I think there is no requirement under the law to get, to do any kind of verification of the information that a person provides as to whether they're a minor or a major, or a person with a disability who has a lawful guardian. So you basically, most organizations are likely to go by self-declarations. Anybody who says they're above the age of 18 but are actually a minor, we will just go by that self-declaration, for example, right? Now, whether that's how a data privacy law which deals with child data should work or not, I think that's sort of like a utopian question to me, or to be quite honest. But if I break it down to compliance, we are basically looking at self-declarations. Basis that self-declaration, we are now going to move into a separate kind of a consent journey for them, where they have to ensure that their lawful guardians or their parents are providing what we are calling verifiable consent, which the IT minister on the floor of the parliament said that they're thinking about current digital infrastructure that India has built, like DigiLocker, etc. Now, given the fact that there are massive government exemptions with respect to how they deal with citizen data, and which would basically mean that a lot of these digital public infrastructure services it's going to be interesting to see how the law works with respect to these products, and how they're expecting companies to rely on these products to get verifiable consent. So for us, unpacking that is going to be the big part of dealing with that compliance. I'm equal parts excited and equal parts worried, to be quite honest.
And since you're at time, and because you brought this up, I do want to get like one final question in, which is on the fact that this law also seems to have what looks like the power to block access to information, which is a slightly unusual provision in a data protection law, because as far as I'm aware, the government already has power for investigations, etc. You already have search and seizure powers. The enforcement authority already has the power to, call for any information necessary. But in addition to that, there is the power of the central government to essentially there is a somewhat complicated process involved, but there is the power to essentially block access to some kind of information. And this is obviously coming in a context where blocking of the internet is super common in India, blocking, say, people's tweets, etc. That is also something that many people have sort of complained about. Jhalak, do you have any perspectives on this, especially in the context of like everything else, like where it's coming from, what's the utility of it, anything you have to?
Yeah. So it's interesting because this is again one of those provisions that came in just in the last iteration. And it's again something that people are really struggling to understand how it's going to play out. And basically the Data Protection Board, if it's imposed a monetary penalty more than twice on a digital service, it can advise the government to block that service on the grounds of general public interest, which is a fairly wide sort of term, and it's again not been defined within the law. It basically adds to already wide powers under the Information Technology Act within the Indian context that permit the government to block websites and online services. And as you said, the government has used this power frequently. And something like this obviously has significant implications for freedom of speech and expression. Particularly because many of these blocking orders are kept confidential and users don't know always when tweets or posts are being blocked. But I think perhaps if we step back and we look at it, of course there are two aspects to blocking. One is content blocking and one is blocking of a business and a digital service. And I guess perhaps where this is coming from is if a business is repeatedly sort of not complying with, provisions of the law, and, the regulator or the government should have a mechanism to bar it from being able to process data of individuals. But I think that the challenge is the inclusion at this final stage without scope for public engagement really didn't give us the opportunity to help perhaps frame and tailor this towards really maybe dealing with the concerns around being able to block a particular business that may be unethically dealing with data. So at this stage, it's just such a broad provision that it's open for use in many different ways, and the fact that it's general public interest gives a very wide ambit to the government to exercise the powers.
Yeah. Well, we are at time now, so thank you both again for coming, and thank you to all of our attendees for joining. We'll we'll share more information on this on the Foundry page. Keep an eye out on that, and have a good day.
Thank you so much,
Thank you.
Raktima.
Thank you so much.